It is better that some innocent men remain in jail than that the integrity of the Canadian judicial system be impugned. I adapt this from the same quote referring to English law by the English lawyer Lord Denning. Lord Denning, out of concern for a discourse within the justice system, adapted this from Benjamin Franklin's original quote, that it is better 100 guilty persons should escape than that one innocent person should suffer. As typical with social justice warrior complaints, there were comments or words taken out of context in the case at the heart of the Judge Robin Camp controversy. This controversy revolves around bringing the Canadian justice system into disrepute. However, it is the feminist social justice warriors of the scholarly kind that are worried about their ideology not convicting enough men unaware of the complex, contradictory, anti-male sex crime laws, rather than the general public being exposed to the machinations of a justice system that may be convicting innocent men. In the re-education of Judge Camp, what we are witnessing is one example of the attempt to establish feminist ideology across the entire Canadian judiciary. Keep your knees together! Judge Robin Camp is too incompetent to remain on the bench, says an article by Vice.com. What all the media has led us to believe is that Judge Camp is an incompetent misogynist that should never judge another criminal case, let alone sexual assault cases. The argument against him is that he does not know the law. What that argument is revealing is that there already exists a special area of sexual assault law that, when applied, amounts to a lower standard of proof in criminal court cases, which in turn deprives the accused of a meaningful defense and a fair trial, and puts the accused at risk of a wrongful conviction. Judge Camp knew this. This fact reveals itself in the trial transcript of the case in question, R versus Wager. After reading the entire transcript, which I've linked to below in the description bar, I come to the conclusion that Judge Camp rightfully challenged the feminist legal precedents and criminal code provisions, also known as the rape shield laws, as unfair to an accused. Cherry-picked unhelpful comments he made aside, what I saw was a judge who was actively and fairly participating in judging the case while trying to ensure he came to the correct and just verdict by ensuring he understood fully the arguments from both the Crown and the defense. If he felt there were some points that needed clarification, he would question the witnesses and the accused directly while they were delivering testimony. Regarding the knees question, the judge was trying to visualize the actual alleged rape scenario based on the testimony given by the complainant. He questioned her because his visualization wasn't making sense. Therefore, he needed to be sure whether or not her claim of how the rape took place made sense. Or in other words, if she was lying about actually having consensual sex with him. The knees question was asked to help him make that determination. He was inquiring to determine whether or not the complainant's story was credible. When it came to the closing submissions, the Crown essentially asserted that the judge must convict the accused based on what is said in the R versus Ewanchuk precedent, which I highlight in a previous video. All in all, the judge admitted that none of the witnesses in this case were particularly credible, given they were all homeless alcoholics and drug addicts with criminal records having a party on the night in question. Nevertheless, the Crown pressed on, despite the complainant's story being full of contradictions, despite two other witnesses supporting the defense's version of events, and despite the onus being on the accused to prove he obtained consent, essentially proving his innocence. All these things go against the fundamental principles of justice, and would all be grounds for a miscarriage of justice in the context of any other criminal case. It's already accepted that a woman who was drunk at the time of the alleged rape is legally considered to be a credible victim of no consent, rather than what one would reasonably consider to be an unreliable source of testimony to give an account of what happened while she was in a drunk and high stupor. A reasonable person would expect a she said, he said case, like the one Judge Camp heard, to never make it into a courtroom. An unfairness that is also accepted in Canadian law is that a woman's unsavory history cannot be used against her when she's claiming rape to imply she might be lying. Yet, an accused's unsavory history can be used to paint a picture of an unlawful man who is more likely to lie in his denial, and his attempt to prove that he did obtain consent becomes neutered by all the feminist-fueled preconceived notions. So, Judge Camp asked all the questions he did to ensure he wouldn't be committing a miscarriage of justice against the accused, regardless of the Crown's assertions of feminist laws that insist he must convict. In my view, Camp's only mistake in this trial was that he outright challenged feminist laws as being contradictory and unfair to the accused. Here's how he does this. 1. He challenges Section 276 as a law that hamstrings the defense. The Crown expresses concern about dangerous thinking engendered by the defense's line of questioning, while the judge quips back, "We're not talking about dangerous thinking, we're talking about the law." And he continues to say that the law doesn't stop people thinking. This exchange continues on, and at one point the judge states, "I'm concerned about interfering with a proper defense," and that one should be careful of how to apply Section 276. This entire exchange is lengthy and is on pages 57 through 64, and I encourage you to read it. Next, he challenges the fact that it's a historic case and goes against the recent complaint doctrine that was used for thousands of years by civilized systems around the world. This exchange can be found on page 145. He also challenges the Crown's antiquated and Victorian thinking that it's very strange that two people would have sex in a bathroom the first night they met. This can be found on page 319. He also challenges the unfairness of the rape shield law, found on page 217. He challenges the lack of the definition of sexual assault, which is found on page 368, and I've also highlighted this in older videos. He challenges the Crown's suggestion on how to apply the WD test for beyond a reasonable doubt. This discussion lays bare how the WD test can easily be misapplied by a judge taking direction by a biased Crown. I've highlighted the WD case and why I think it should be overturned in a previous video. The extensive inquisitorial discussion in this trial takes place on pages 370 through 403. He challenges the extreme consent law and how it goes against the way of the birds and the bees, found on page 384 and 385. He challenges whether or not the accuser saying she didn't want to have sex without a condom constituted as a no consent issue. This discussion can be found on page 390 through 393. Judge Camp's method in coming to his verdict was essentially to soak up as much as he could about the unfair and contradictory feminist laws so that he could craft his acquittal verdict in a way that would be appeal-proof. He makes no secret of this. I agree that in the process, a few things he said could be considered out of line, of which he has apologized for, but nothing that in my mind constitutes a removal from the bench or sexual assault trials, and nothing that constitutes the public defamation and humiliation campaign currently underway. What resulted from this trial judgment was a band of academic rabid feminists wanting to put a halt to the possibility of an acquittal like this ever happening again, wanting to ensure that they can re-educate judges like him to view the feminist laws as the law of the land in sexual assault trials, and to replace judges like him with feminist judges. And wanting to ensure that it gets easier and easier to convict innocent men and get away with perverting the course of justice by making such miscarriages of justice the new normal. As of the date of this video, the fate of Judge Camp's judicial standing has yet to be decided. But with the few nuggets that have been released by reporters from this inquiry demanded by feminist scholars, it is implied that they are not satisfied that he has been sufficiently re-educated on feminist law to get back on the bench. Interestingly, but not surprisingly, it turns out that Lori Haskell, the same feminist psychologist who told CBC some quackery that counting the number of holes in a ceiling tile can prove a woman was raped, which I highlighted in part 4 of my series, Evolution of Feminist Theory, Moral Panic and the Law, Lori Haskell is the therapist assigned to re-educate Judge Camp. So we shall see what the outcome of Camp's inquiry will be. In the meantime, however, the Globe and Mail has reported that 4 other Alberta judges are under fire for similar circumstances. I will link to the article below, and you can do your own further research on these cases. But my comment on this is that it is becoming painfully obvious that there is an inconsistency within our judicial system in terms of adhering to feminist legal precedents in criminal court judgments. There is also an inconsistency in crowns submitting to judges feminist laws that they say dictate a conviction. In other words, not all crowns demand a judge convicts based on feminist precedents. And not all judges will convict based on feminist precedents, as we saw with the Jian Ghomeshi case. But some do, as we saw with the Mustafa Uriar case. What we have right now is a sweeping attempt by academic feminists and opportunistic lawyers to push for a judiciary and a prosecutorial system that only tries sexual assault cases with specialized feminist ideology that ignores the rule of law and the fundamental principles of justice. Essentially, feminists are currently on a rampage to ensure every man accused of a perceived sexual misconduct on any level gets convicted and goes to jail. And feminists want to encourage any scorned, delusional woman to lodge a complaint to the police, whether true or false, to help solidify these laws as permanent fixtures within our legal codes. Why aren't we seeing the mainstream media question this injustice in the making? Thus far, I've only seen a unanimous consensus that Judge Camp was out of line with a few of the comments he made and should be punished for it, minimizing the whole entire context of this issue and without questioning the nefarious discourse against the fundamental principles of justice that's really going on. The feminist faction at play here is proving themselves to be a fascist faction by denouncing Judge Camp's use of reasonable common sense to come to an obvious acquittal verdict. His brand of everyday logical reasoning and common sense, like yours and mine, goes against all the myths and stereotypes created by feminist scholars that essentially say when a woman claims rape, she is never lying because the man is inherently in a position to overpower her for his uncontrollable sexual desires, and they remove every opportunity for an innocent accused to successfully defend himself. Whether or not men and boys can be raped too has nothing to do with this. That's a red herring used to justify the continuous use of feminist theory to convict anyone accused of sexual assault. In fact, all of it is a red herring to justify the continuous arrests and prosecutions of innocent people who cannot prove that something didn't happen in the face of an accusation against them that comes with zero material proof and corroboration. Simply put, these theoretical laws are in place to justify jobs, bureaucrats, and government funding that only enrich the corrupt and the fraudulent. A judge like Robin Camp, who plainly saw through that, is a threat to them, and the mobilization of the rabid feminist campaign to re-educate him and other judges like him is a clear sign of that. Just look at the appeal factum that was accepted by the appeal court to overturn Camp's acquittal of Wagger. It reads like a women's study thesis based on a high school drama. It is ridiculous. And the fact that the appeal court agreed the Crown should have another shot at convicting and jailing this man, and the fact that the judge is being publicly shamed, is disgusting. Why does this feminist faction feel the accused needs to be further harassed and jailed? Well, because they can't allow the judge's verdict to stand and be used as a benchmark for other future acquittals in cases where credibility is the only deciding factor. Which might also explain why the reasons for judgment are not available for the public, law students, and lawyers alike to read on the canley.org database. The unavailability of this document supports the claim these feminists make that judges need to be educated on feminist sexual assault laws that subvert the age-old fundamental process of deciding a case based on provable evidence and the absence of provable evidence. Keeping logically reasoned acquittal verdicts away from the eyes of others is an effective way to systematically force the dominance of illogical feminist theory within the legal landscape. Please review all the source materials linked in the description bar below, including the trial transcript, and decide for yourself where the injustices truly lay.